The matter I'm going to be discussing, well, preparing for court the 19th of July 2021, appeal to the Jamaica Appeals Court on a ruling by Justice V. Smith Vaughan Smith, where Justice Smith essentially just arbitrarily and capriciously just walked into court, withdrew an injunction applied for from the claimants, and then made a determination that no damage was done to the second defendant because the injunction was not taken out against the second defendant. This is an injunction that lasted for 5 years, which is ludicrous. So there are a number of issues that will be addressed at court, and I think some of the main issues are, one, the constitutionality of the action of Justice Vaughan Smith, the constitutionality of the injunction in the first place that shouldn't have been granted, and any other provisions that the Constitution gives in terms of protecting that right. So, and it's extensive. The protection the Constitution offers is extensive. For one, this case was already dismissed by the Supreme Court on May 29, 2015, and on concerns raised by the claimant that they didn't understand the judgment, even though the judgment clearly stated their case was dismissed. The learned judge decided she was going to do a clarification, and that clarification occurred or was delivered on the 23rd or 24th of December 2015, almost 6 months after. So this matter has been in court for more than a decade, approximately over 12 years approaching, and still the lower court, the lower tribunal, judges in the lower tribunal refused to dismiss and give a final order on this case. And now the game the claimant played was to, after the first claim 2010 HCV 02692 was dismissed by Justice Beswick, less than a month after the clarification order, or the clarification delivered by the judge, the claimant went back and filed the very same suit, seeking the very same remedies concerning the very same issues against the very same defendants. So there are quite a few grounds on which this case should have been dismissed and must be dismissed. So I wanted to make sure that I got it back in front of the appeals court, because I've been waiting since 2015 to have certain orders given, and the lower tribunal judges, and it would seem in collusion with other officers of the court, took certain measures or lack thereof that would allow this matter to continue unresolved, even though the law said it should have been resolved, and not only resolved, but resolved in our favor, because we got the judgment and we complied to every order we got, and still the 7th of July 11, 2021. So one of the first questions we'll be addressing to the court is, why has this matter not been fully dismissed? And as a matter of law, it must be. And based on Rule 2.7 or Part 2.7, where it says a court can deal with a matter anywhere it's convenient and convenient to the parties. Now, in this particular instance, my lord and my ladies, the convenience is well established. The matter is properly in front of the court, and the defendants are here and the claimants are here, and they're fully represented by competent parties. So in order to resolve primary issues across the board concerning all the connected or associated cases to this matter, my lord and my lady, I think this is a convenient forum for it to be addressed. So one of the first things I'll be asking the court to do is, upon the law being looked at and it being pointed out that this case must be dismissed, I'm asking the court to dismiss it instantaneously or automatically. And in fact, I'm asking the court to also adopt a rule that any matter that's been in front of the appeals court and the appeals court has determined that that matter has no standing or claim and definitively made a statement to all the parties that the claim should be dismissed, that if it becomes an automatic dismissal of that claim, and if it's sent back to the lower tribunal, then it's automatically the first judge it comes in front of must, by an adopted rule, dismiss that claim, because it's not only waste the time of the parties involved, but waste the resources, and it does create a problem for the judiciary and generally the trust we need to have established and maintained in the judiciary. If matters are ruled on by the appeals court and it goes back to the Supreme Court, and the Supreme Court judges refuse to act in accordance to the rulings or the judgment of the appeals court. So this matter, by law itself, without me even discussing it or going into much detail, my lord and my ladies, is that it's back in front of the court. The court already determined it should be dismissed. It was in fact dismissed, and yet the claimants again refile and are back in front of the court on the same issues. So there is a mandate that would suggest that the court automatically strikes this matter as being already a settled matter. Now, in this particular instance, the claimants again keep coming back with the same allegations and relying on a sales between two parties that they have no relationship with, and the court determined that they have no interest in. The court determined that, and yet here we are again challenging orders about a contract that was already ruled on by the court that is not in their purview. So that's another ground for it to be dismissed, my lord, because once my lady, is that once the court had determined that this contract must be dismissed, and they have no relationship to the contract, raising the contract or trying to get to the contract to establish a cause of action some 10 years later is not going to help their cause. This contract, my lord, in fact, is more than 17 years. It's approaching 17 years closed, and they have no relationship with it. So by virtue of a number and I'm pretty sure there's a ton or bodies of laws out there, that means this case is automatically dismissed on one, constitutional grounds, two, rulings of the court, the fact that, my lord, they have used fraud as a matter of fact, and I'll elucidate on other grounds, but typically we're not here to waste the court's time. So first of all, my lord and my ladies, I'm going to address the issue of the orders that were already granted, or the judgment that was always granted as primary ground for automatic, instantaneous dismissal of this matter. And, my lord, the parties, the claimant, refiling this document over and over, this case over and over, should be sanctioned by serious costs and fines, which are also deserving to be compensated, the defendants. We've been dragged for almost 12 years back and forth to the United States and Jamaica in between at great cost, inconvenience, and damage to our health, or my health. And I'm still here, So on average, I used to be traveling to court on this and related matters, sometimes twice 3-4 times a year, and the matter was already ruled on. So in terms of part 1 of the civil procedure rules, my lord, this case must be dismissed on that part, giving effect to the civil procedure rules, part 1, dealing with a case justly. It cannot be just for a matter that's dismissed some 5 years ago fully and ruled on more than 11 years ago by the appeals court that it should be dismissed, that the defendants are being dragged back and forth at great cost and inconvenience, and now are the victims of a fraud. And one of the things Justice Vaughan Smith did was simply just walk into court and say, these guys, well, the second defendant suffered no damage. And then they came back to court. When we went to court recently, and they wanted the court to rule that no cost should be paid to the defendants. On what ground? None. Claiming or suggesting or implying that there was some impropriety in the contract, or some letter from a U.S. firm dealing with this contract that the court ruled that they have no standing to even be discussing. So I'm going to ask the court, first of all, to make a couple rulings, because these are rulings that the court can make without further ado. And one, we're claiming the contract and any related matter to the contract and the dismissed claim as exclusive or proprietary or privileged to the defendants, and the defendants have no need for exposing private matters in that case, in this affair, and this case, and the claimant has no right in those agreements. So we're claiming privilege, Your Honor. We're asking the court to rule on the inadmissibility of that contract and any relations to that contract to be used in any applications by the claimant, who have the court ruled does not have any right in those agreements. The second thing we need to establish, my lord and my lady, is that we have here representing, quote unquote, Business Ventures and Solutions Inc., a defendant, Alexis Robinson, who is also an associated or related attorney for Capital One, and she claims she's representing Business Ventures and Solutions. And one of the main issues with that, my lord, is that we've voiced opposition to her being here in the capacity of any legal representative for Business Ventures and Solutions Inc. She can represent any party that the claimant has retained, but Business Ventures and Solutions Inc. of 6726 3rd Street in the state of Florida, which is a foreign corporation that was established in Florida and was party to that dismissed claim and to this claim that's also in front of the court. And, my lord, a third claim which the claimants filed again, asking for injunction, which was granted inadvertently by Justice Barnaby, and I'll come to that later, my lord. But in short, where was I? I've lost track. But the matter is that they have no interest in the contract. Miss Robinson is here again fraudulently, and I say fraudulently, my lord, because we have given Miss Robinson the opportunity to go do our research, look at all the filings, look at all the documentations and the rulings of this court, the ruling of the Supreme Court, ruling of both Justice Beswick and Justice G. Brown, and the documents that have filed. And all those documents clearly show that Capital One or the Alexander Burnham Trust has no legal claim or right in anything belonging to Business Ventures and Solutions. Especially, my lord, when Business Ventures and Solutions was an administratively dissolved company, not able to transact business of any kind or employ anybody except through its rightful owners and directors. And when that company was sold off in August of, I think August 17th of 2017 to its successors in interest and other parties that had an ownership interest from then, and those sales agreement certified, authenticated, and filed on the court's records from 2017, and Ms. Robinson is showing up in 2020 alleging, or 2019 alleging, that Capital One, through its employee, Ms. Lorraine Gallagher and Stephen Rapier, has retained them to represent Business Ventures and Solutions, Inc. And so that in itself is, fraudulent, because the misrepresentation is being done to encourage judges or fool judges into believing that she has a legitimate standing and that she's supposed to be here. Now, first of all, my lord, the court had already ruled that Anthony Tharpe, me, is a party that represents Business Ventures and Solutions. On May 16, 2018, Justice G. Brown. That is beyond question. It cannot be disputed. It's been ruled on, it's been understood and filed in several documents, and Ms. Robinson was made aware of that, or Miles Fletcher and Gordon was aware of that when they showed up in court, and we said to the judge, we don't know this lady. That was done on the 25th of November 2018. This is just a couple of months after